The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 916, coming to you on Monday the 8th of October 2018. On this program, I will continue the topic I dealt with in the past 2 weeks. So this is Procedural Safeguards in Death Penalty Cases, Part 3. But before getting into the topic, a brief preliminary remarks. Condolences go out to all families which have suffered recent bereavements. And as you all know, we in the Spiritual Baptist community are still mourning the loss of our Archbishop, His Grace Frank Simon, the Reverend Mother Labette Young, both of whom died in an accident on the 30th. And we thank God for the delivery from death of Reverend Mother Philomena Tittle and also Brother Ezron Pompey, both of whom were involved in the same accident, but both of whom survived. Reverend Tittle is out of hospital, but Brother Pompey is still there, and we wish him God's blessings. The funeral for our departed Archbishop would be held this coming Sunday, the 14th of October, and the funeral of Reverend Mother Labette Young will be on the 21st, the following Sunday. Details of both funerals would be given in radio and television announcements. Now for the topic of the evening. Well, I was prompted to do a third program on the procedural safeguards by reason of the many persons who responded to the previous programs. Some had heard part 1 and not part 2. Some had heard part 2 and not part 1. And other persons said they wanted some assistance with the numbering as to which one was number 6 and so on. So I said, you know what, I will do a summary program where I will go through the 12 safeguards which I have identified in the criminal procedures in St. Vincent and the Grenadines relating to death penalty cases. Fairly rapidly, I would not be able to devote as much detail to any particular safeguard because I must finish all 12 in this program since I want to move on next week, Divi, to another topic. And I will enumerate the programs. So those of you who plan to take notes, get your pen and paper ready. And remember, I am speaking about the laws and criminal procedures of St. Vincent and the Grenadines, not necessarily any other country, although much of what I say would also be applicable to many of the constitutions and the criminal systems of the Caribbean, especially the OECS, but I'm dealing specifically with St. Vincent and the Grenadines. As I said before, if I were living in the United States of America, I would probably not support the death penalty because in the United States of America and in many other countries, mistakes are made from time to time. The wrong person is convicted and executed from time to time. Sometimes the mistakes are caught at an earlier time, that is before the execution, but sometimes it is not until after somebody has been executed in America that years after it was discovered that they could not have been the person who committed the offense for which they were executed. And I brought these programs in the context of the debate on the death penalty. There are many persons who are instinctively opposed to the death penalty. And I've said before, I have very good friends who are of that persuasion. Other persons, like myself, are in favor of the death penalty in St. Vincent and the Grenadines, because by the time a person is on the gallows in St. Vincent and the Grenadines, the chances of that being the wrong person are negligible as to be non-existent. And when I go through the 12 safeguards, you will see why, with all human failings, it is still almost impossible for the wrong person to be executed here. In that, if a mistake was made in identifying the person or the circumstances somewhere along the line, that mistake would be identified in our system before the person reaches the gallows. So therefore, here goes. The procedural safeguard number 1 is that before anybody can be even put on trial for murder or any other offense that carries the death penalty, that person has to be found by an examining magistrate to have enough evidence against them to warrant being put on trial for the offense. We have preliminary inquiries, PIs as they are known, where the prosecution at the magisterial level has to lay out its main evidence against the accused person and satisfy a magistrate that that evidence, if believed by a jury, could result in the establishment of guilt against that person. So that is the first safeguards. Procedural safeguards number 2, 3, 4, 5, and 6. Well, you could even include 7. From 2 to 7 have to do with the procedures during the trial. Number 2 is that nobody can stand trial for a capital offense, that is, an offense which carries the death penalty in this country, without having legal representation. If the person cannot afford a lawyer, the government has to provide a lawyer. So there's no such thing as a person going through a murder case undefended by legal counsel. Procedural safeguard number 3, jury trial. In this country, capital offenses, along with many other serious offenses, and I'm speaking about death penalty cases. So what I say also applies to some indictable offenses or most indictable offenses. But I will not keep repeating myself. You would know when I speak, I'm speaking in the context of cases which carry the death penalty. So procedural safeguard number 3 is that we have jury trials where a jury at the trial of a capital offense must consist of 12 persons, of whom at least 10 have to find the accused guilty, so that anybody who ends up being found guilty of murder in St. Vincent and the Grenadines would have been convicted by the votes of at least 10 Vincentians sitting on the trial, hearing the whole proceedings. Safeguard number 4, the presumption of innocence. In this country, the Constitution prescribes that a person charged and tried for a criminal offense is presumed by the law to be innocent until that person has either pleaded guilty or has been found guilty. There are some countries where after an examining process and at the trial, you have to prove your innocence, particularly in some civil law countries, not in our system. Procedural safeguard number 5, the rules of evidence. The rules of evidence are there to be administered by the judge presiding over a trial. The rules are very elaborate. Basically, they are designed to weed out evidence which is irrelevant or prejudicial to the accused person without having any merit, hearsay, and that sort of thing, so that the prosecution producing evidence before a judge and jury in a death penalty case has to stick within the guidelines prescribed for proper evidence taking. Therefore, you would hear defense counsel during a trial rising and objecting to certain pieces of evidence and telling the judge so-and-so that evidence should not be admissible. The judge will rule on the objection, and according to what evidence it is and how it is sought to be introduced, he would either allow the evidence or disallow it. He'll tell the prosecution, you cannot put in that piece of evidence, or you cannot put that evidence before the jury in that form. And judges are very strict with prosecuting authorities, who incidentally have to display to the accused person before the trial all the evidence they intend to bring against him or her. Correspondingly, the accused person hasn't got to reveal their evidence, so that when the accused person is called upon to present his or her defense, most of the time the prosecution is taken totally by surprise because they have no idea what the defense is going to be. But the accused person has to be told in advance of the trial every piece of evidence that the prosecution intends to bring against him in the criminal trial. The defense has to know. And this is one big advantage that defense counsel has. If the prosecution conceal evidence and try to spring it at the trial, defense counsel would object on grounds that that evidence was not disclosed before at the disclosure stage, and the judge in all likelihood would say, no, you can't bring that evidence now, and take the accused by surprise. But the accused is allowed to take the prosecution by surprise when it comes to the time for the accused to make his or her defense. You might say it's unfair to the state, unfair to the prosecution, but there it is. That's a big advantage which accused persons have in criminal cases. Safeguard number 6, the strictness governing confession statements. Very often prosecution have as their trump card a confession or an alleged confession by the accused. Well, the rules governing the admissibility of confession evidence are very strict. The prosecution have to prove, before they are allowed to put in a confession statement against the accused, they have to prove that the statement was voluntary. So you cannot force an accused person to confess and then bring that confession statement to the court. And if the accused person objects, having given a confession or an alleged confession at the police station, even before a JP, he can always challenge that at the trial, and the judge will have a trial within the trial. called a voir dire, aimed at establishing whether that confession statement was really voluntary, not produced by means of intimidation or threats or promises or violence. In other words, the prosecution has to come strong. Now, procedural safeguard number 7 is the summing up, because it is the duty of the judge in a criminal case to sum up the evidence for the benefit of the jury. The judge will issue certain warnings. He will tell the jury what standard of proof they have to look for. That is, they should not accept something as true unless they are satisfied that it was true. And he will warn the jury that they have to find a person guilty on a preponderance of the evidence. He will tell the jury they cannot go with what they have heard on television, what they have seen in newspapers and so on. The judge will persuade the jury or instruct the jury that they must rule on the evidence they have heard and only the evidence they have heard during the course of the trial. Not what they have heard on the road or what they have seen in social media and so on. They're not supposed to take that into consideration when they go to deliberate. Summing up is extremely important. And most cases which go on appeal and are won are usually won because of a defect in the summing up. Certain rules the judge has to follow, certain things he must tell the jury, he must explain the ingredients of the offense, tell them what they have to find before they can establish guilt and so forth. Very important, the summing up. And that is an important safeguard. And then we come to a recently, when it's a recent, within the last 15 years or so, a development in the law affecting St. Vincent and the Grenadines and other countries, but let us talk about St. Vincent. In days gone by, if a jury brought in a verdict of guilty of murder, the judge had no choice but to put on a black piece of cloth over his head or her head and pronounce that the person is sentenced to death by hanging. Once the jury said guilty of murder, it was death by hanging. That was changed a few years ago. The courts have ruled that the automatic imposition of the death penalty following a guilty verdict in a murder case is unconstitutional. So the new procedure is that if a guilty verdict is brought in by the jury in a murder case, the judge has to adjourn for sentencing. That is another day, not the same day, not the day after, days after. Another hearing has to be held called a sentencing hearing. At that hearing, the judge will listen to evidence from the prosecution and from the defense as to what punishment would be most appropriate for the circumstances of that finding of guilt. And there are guidelines which, in a sense, tie the judge's hand, because the guidelines predominantly say that unless the circumstances of the killing for which the person was found guilty was such as to be so horrible that they came within the umbrella of what is called the worst of the worst, the judge cannot impose the death penalty. He has to impose some other penalty, life imprisonment, imprisonment for X number of years, and so on. It is not enough that the killing was bad, it has to be really horrible. I don't know as yet, and many lawyers don't know, what would qualify, because the cases from St. Vincent that have gone to the Privy Council after this new rule, the Privy Council has said as bad as they were not the worst of the worst, and those persons should not be hanged. So we're waiting to see what the Privy Council would deem the worst of the worst. Okay, so all those safeguards I've read you from number 2 to 8, 8 being the sentencing hearing, occur within the trial. Now, after the trial, come safeguards 9, 10, 11, and 12. Safeguard number 9, I have called the appeal process, where anybody convicted of murder, and indeed any other crime, has the right to appeal to the Court of Appeal. And if the appeal is turned down, they have the further right to appeal to the Privy Council. If that is turned down, they have the right to appeal to human rights international bodies. And in the hearing of those appeals, the appeal courts, be it the Court of Appeal or the Privy Council, will go over the case quite carefully to try and see if any of the grounds of appeal had substance. And the appeal courts, I can tell you, look to see they look at the whole trial, they read all the papers, the whole transcript of the trial, to see if the person got a fair trial. So that if after all of that, the appeal is turned down by the Court of Appeal, and it goes to the Privy Council, and the Privy Council turns down the appeal, and it goes to human rights bodies, international bodies, and they turn down the appeal, that is not the end of the line for the accused person, for the condemned man. We come upon procedural safeguards 10, 11, and 12. These all have to do with the Mercy Committee. The Constitution of this country has set up a Mercy Committee consisting of a person designated by the Prime Minister as chairman, and the Attorney General, and at least 3, possibly 4 other persons, one of whom must be a minister of religion, and one of whom must be a registered medical doctor practicing in the state. That's the Mercy Committee. And every single death penalty case has to go before the Mercy Committee before the sentence of death can be carried out. Everyone. So the 3 safeguards are: 1, the composition of the Mercy Committee; 2, which is number 10, the composition; number 11, the judge's confidential report. The Constitution says that at every hearing of the Mercy Committee on a death penalty case, the Mercy Committee must take into account the confidential report of the trial judge. They can't just have a meeting without having the report of the trial judge on the trial, by which they are guided, so that if the trial judge had any qualms any doubts whatsoever. Of course, he would have, if he had serious doubts or any doubt, any appreciable doubt, at the sentencing stage, he would not have imposed the death penalty. But in spite of that, he has the right to write a report which only the Mercy Committee sees. And I can tell you from being on the Mercy Committee for 8.5 years when I was Attorney General, it is a responsibility which the Mercy Committee takes most solemnly. And the final procedural safeguard is at the Mercy Committee, there's the rule of unanimity. All 5, and in my time, there have never been 6, even though the Constitution will allow 6. All 5 have to agree on the decision to hang before that decision is carried into effect. So that when you look at how these safeguards are spread out with constitutional force, to me it is impossible for mistakes or even a mistake to be made in a murder case that would not be picked up somewhere along the line, either at trial, at sentencing, on appeal, or before the Mercy Committee. And if all those persons who have to deal with the case say this person should hang, then one could entertain no doubt of the guilt and of the person and the appropriateness of the death penalty. So that in summary, whatever quarrels you may entertain about the death penalty, don't come with the argument that you're against the death penalty because they might hang the wrong person. Not in this country. It can't happen, I'm telling you. Not with all these safeguards there. You may say the person, you may feel sympathy for the person and the person's family and so on, but to say that the authorities got it wrong and they're going to hang the wrong man, no way. Can't happen. Not in this country and in other countries that have constitutional safeguards similar to ours. You may oppose the death penalty on other grounds, on moral grounds, that it is not right for the state to take human life and so on. But you can't oppose it in this country on the ground that you could hang the wrong person. No way. So I hope I have enlightened you and you now know that it is difficult, if not impossible, for a person with a modicum of innocence to end up on death row in this country and go to the gallows. So that is all from this program of The Law and You. I look forward to being of further service to you next week, Monday TV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.